Hey, it's your girl, your favorite paralegal, aka Cassandra Lynn, and welcome to Legal Talk 24/7. Hey, I am coming to you guys today with a updated court document from the Sean Puffy's criminal indictment. Let's hop right on into it. So, this is a letter that was filed by the joint parties to the judge, and it reads as follows. All right. Hopefully you guys can see this. I'll just blow it one more time. Okay. And I'm reading it as well. So dear Judge Subramanian, the parties respectfully submit this joint letter in response to the court's order dated October 4th, 2024, directing the parties to outline the issues the parties believe should be addressed at the pretrial conference scheduled to proceed on October 10th at 2 p.m., which is tomorrow. So this isn't regarding discovery. You guys have heard me say this term over and over and over again. I cannot stress enough how important discovery is. So here is the government's position. Okay, this is, remember, it's the United States versus Sean Puffy or Sean Combs. So here's the government's position. Discovery in this case is voluminous, totaling several terabytes of electronic material, and consists primarily of the following categories: electronically stored information belonging to the defendants, cell phones, laptops, tablets, hard drives, cloud accounts, etc. Electronically stored information of third parties, cell phones, laptops, tablets, and cloud accounts. Business records from financial institutions, phone companies, hotels, airlines, and other businesses. Physical evidence seized in searches of the defendant's residence, law enforcement records, and search warrant returns, including cell phone location information. Beyond the information set forth herein, the government will be prepared to answer any questions from the court at the upcoming conference regarding the status and contents of discovery, including the various types of discovery, the status and anticipated timeline of extracting electronically stored information, and the anticipated time needed to produce the remaining discovery in the government's possession. That is a lot. This is not something, and I showed you guys yesterday a little bit of discovery. For me, just doing a regular, I would say, car wreck case, okay? The total hours of requesting records, answering interrogatories, producing certain documents, and getting all that ready, it literally takes me 2 weeks. Okay, so just imagine all of the things that they have stated they have obtained and they have to go through. And this is a criminal proceeding. That's a lot. I'm talking about months. If they have to have a big enough staff to sit there and request all of this information and go through all of this information and organize the information. It's going to take a couple of months. But like I said, I know they've been doing this for a while, but they're still getting documents in. The government has been in close coordination with defense regarding the production of discovery in this case. And the government has prioritized the expedient production of the defendant's electronically stored information, which makes up a significant portion of the total discovery in this case. Since the defendant's arrest on September 16, 2024, the parties have engaged in extensive negotiations regarding the protective order, which the court signed on October 4th, 2024, and docketed on October 7th, 2024. On September 25th, 2024, the government requested hard drives from the defense for discovery, and it was received on October 1st, 2024. On October 7th, 2024, the government made its first production of discovery, which included, among other things, a complete set of search warrants in the case, iCloud reports for the two defendants' accounts, and the defendant phone seized on March 25th, 2024, which defense counsel specifically requested be produced in the first production. The following day, as relayed to the defense, the government began copying over 40 devices and the other 5 iCloud reports belonging to the defendant, which is expected to take several days due to the volume of materials. The government also informed the defense that, in addition to those devices and cloud accounts, it expected to make rolling production within the next 30 days of hard drives that were seized from the defendant, the subpoena returns currently in the government's possession, and materials from the searches executed at the defendant's residence and hotel room. To the extent that the defense position below suggests otherwise, the government wishes to clarify that it has been endeavoring to extract devices seized from the defendant as expediently as possible since their seizure. Moreover, the government is producing the defendant's materials in the first instance without responsiveness or privileged reviews. Finally, the government informed the defense that it expected to produce the remainder of discovery, including electronic information seized from devices and cloud accounts belonging to other individuals on a rolling basis by the end of the year. The electronically stored information from third parties must be reviewed before it can be produced to the defendant, and in many cases must be reviewed for privilege. The government's investigation is ongoing, and it will continue to review and produce discovery on a rolling basis as it receives Rule 16 material or as technology advancements allow the government to access electronically stored information that has not yet been extracted. That was the government's defense. Now, here is the defense. I said government defense. That was the government's position on discovery. Now, here is Diddy and his team, his attorneys. Here are their positions. The parties are in almost daily discussion concerning discovery. The defense intends to ask the court to require the government to immediately produce certain categories of information, namely copies of Mr. Combs' electronic devices that were seized over 6 months ago and at the time of his arrest, and certain categories of requested Brady material, and to timely review the remaining Rule 16 material in their possession. For example, the outstanding subpoena returns and electronic stored information belonging to other individuals, many of which have also been in the government's possession for many months. So it's not just, Diddy stuff. It is other people who were involved, their things as well. Ooh, the rabbit hole gets deeper. Through our dialogue with the government, we understand that the government seized a significant amount of Mr. Combs' electronic devices and data pursuant to search warrants that were executed on March 25, 2024. The government also seized additional devices belonging to Mr. Combs at the time of his arrest about 3 weeks ago. We also understand that the government is now beginning to review and copy these electronic devices, including those that were seized on March 2024. The timely production of these materials is critical to Mr. Combs' ability to prepare his defense. And because these devices belong to Mr. Combs, their production should not be delayed by the government's initial review for responsiveness and privilege. The government has indicated that they will be able to produce these devices in the next 30 days. With respect to other categories of Rule 16 material, we intend to ask the court to set a reasonable production deadline to allow for sufficient time to review the material in advance of a spring trial date. So they have not even set trial, only because of the overwhelmingly amount of things that they have discovery. And when I say discovery, the evidence that or the items collected they have to go through. Trial in motion and setting. So on the defense position, Mr. Combs continued to assert his right to a speedy trial and intends to request a trial date in April or May of 2025, and as consistent with the court's trial schedule. Mr. Combs also seeks deadlines for the filing of pretrial motions with permission to raise certain pretrial motions in advance of any deadline. For example, at some point today, Mr. Combs intends to file a motion for hearing and other remedies related to the unauthorized and prejudicial leak of grand jury information. He mad that we can. That's funny. Here's the government's position on that. The government will be available for trial on a set date by the court, although it remains within the court's discretion to set a trial date at the outset of the case or at a later time. Usually, court dates are scheduled for a year out, probably a year or more. I have one case where the trial date is in 2026. Okay. So it's based on their availability. So Mr. Combs, Diddy is asking for a speedy trial, a quick, at as early as convenience. That's what they're wanting. The government says we're available for trial on any date that's set by the court, but it is going to be up to the court discretion to set that date. So I am very interested to see as to what is going down. But as I stated time and time before, we know that discovery is not going to be something that is going to be released to the public only if it leaks out. And I'm pretty sure that they are going to do their best, their absolute best, not to leak out any of that information, because people have to realize everything that they are obtaining right now is what they have to use in court. All right. So anything that's leaked out that would help the governments or the state or the United States of America, they're not going to jeopardize that. Okay. So I feel that both sides are going to do their darndest not to leak out any information, any videos, any photos, anything of that matter that can cause some type of mistrial. And we don't want to do that. So you guys tell me what you think about this letter in the comments below. Don't forget to like, share, and subscribe. Until then, be blessed, and I'm out. Bye.